Welcome to another in our series of interviews with Vice-Chancellor's Professorial Fellows at Monash University. And right now I'm honoured to be able to speak with Marilyn Warren, the former Chief Justice of Victoria, among many, many other things. It's great to be here with you, Marilyn, and I'm looking forward to our conversation very much.
We are seeing a very extraordinary event occur that no one would have anticipated 5 years ago. We in the Supreme Court had progressed a long way such that we had the capacity to stream trials and appeals. Some people thought that the streaming of Cardinal Pell's hearings was the first time that had occurred. But in fact, we had significant cases in the Supreme Court, the Great Southern Commercial proceeding, and that was very much a dress for rehearsal for another big class action, the Black Saturday bushfire case. Now, the key to, or the significance of the Black Saturday case and the use of technology was, first of all, it was a case run before a single judge, but at any given time there could be around 60 lawyers in the courtroom. The judge, Justice Jack Forrest, banned folders and trolleys from the courtroom, which of itself was revolutionary. And the lawyers had to function digitally. The giving of evidence and the use of technology was absolutely maximised. But the super important aspect of that case was this. In the Black Saturday experience, 173 Victorians died in the most tragic circumstances. It was all very well having all the lawyers in the room, but the victims' families and those associated with them may not have wanted to come to court to observe what was happening because of the exposure of their grief and indeed the compounding of their tragedy. So we in the Supreme Court utilised the technology that people were able to have streamed into their kitchen or lounge room, wherever, and watch privately in their own home the evidence being given. And I thought that was such an enablement of access to justice that was absolutely breathtaking. Subsequently, we've seen that picked up in royal commissions and boards of inquiry. And so there is an accessibility by the community and a capacity to observe justice being played out. Now, I mentioned COVID-19. On any given day in the Supreme Court, the members of the community can, as if they walked into the courtroom, actually go to the court's website and dial up, as it were, Supreme Court channel. And they can see judges sitting, they can see the barristers with split screens, and it's now commonplace. It's still not appreciated fully by the community, but it is a remarkable facility to the general community. And as I have said a number of times recently to law students and young lawyers, this is a magnificent opportunity to actually observe lawyers exercising their craft. So all around, it's been an absolute bonus for all aspects of the administration of justice. The journey is not yet finished, but there are some wonderful milestones that have been achieved. But just winding back to when I started at Monash over 50 years ago, the women were outnumbered 10 to 1, whereas now it's flipped to about 60% plus of the law students are women. When I was Chief Justice, one of my functions was to appoint, admit to practice new lawyers. So this is where they gain their license, as it were, to practice. And I put through something like 15,000 in my time. And I saw the numbers rapidly rise where women were dominating. The disappointment is that the numbers are not reflected in the experience and role being played by women in the law. I happen to be privileged to be patron of a body called the Victorian Women Lawyers, and it's made up mostly of young women lawyers, and they're very devoted to not only promoting women as lawyers and giving women an opportunity, but to have the needs of women recognised in the workplace, flexible workplace practices, recognition of the childbearing years, family-friendly arrangements, all of those sorts of things. We're still working through that. And one of the things, again, that has come out of COVID-19 and working at home is I've spoken to numbers of students, women lawyers and academics who have found the whole experience very challenging, trying to juggle homeschooling or managing a little toddler and continuing their practice. So we have a long way to go. When I was a young lawyer, there weren't any women judges. So I didn't have a visual role model whom I could look at and think, one day that might be me. And I was very struck by this. In 1996, I was a barrister and things were going fairly well at the bar. Again, I was at that time fairly much one of a minority, but I was progressing. And there was a special welcoming ceremony for the first woman appointed to the Supreme Court of Victoria. It took until 1996, Justice Rosemary Barnford. I remember standing in the Banco Court when Her Honour came into the courtroom, and it actually caught my breath to see a woman. And it might be difficult for men to understand this, but to actually see a woman in the role, it was breathtaking and inspiring, and also a relief to see, yes, we have a woman and she can do that. I had a lot of apprehension about the burden, about acceptance, and I also had apprehension about whether I had the capacity to be a leader. We need to bear in mind that I hadn't been to business management school, I hadn't been a CEO of an organisation, and also at the time I was asked, I was one of the youngest judges on the court, and the court had many senior judges who were considerably older than me. They were very wise, very clever, and here I was the one being asked to take on the role. In the end, there are a number of reasons why I accepted the role. I had a sense of duty and obligation to the court itself, because I had a deep and abiding love of the Supreme Court right back from when I had been an article clerk in the 1970s, and that had only grown over the decades. I had a desire to make a contribution. I had a very strong sense of public duty and commitment to the community. This was to be an extraordinary opportunity. I also had a strong sense of duty to gender. There had never been a woman in the Supreme Court, and if I had declined the government's offer of appointment, well then perhaps a man might have been appointed and Victoria would have had to wait longer. life as a barrister is one of the most exhilarating, best jobs around, because you never know from one day to the next what case you'll be working on. No facts are the same. You have the sometimes terrifying adrenaline rush of having to prepare a case and you don't have much time and you have to be on your feet persuading a judge or a jury, as the case may be. And the exhilaration and adrenaline rush comes not from the egotistic aspect of being on your feet and performing as you do as an advocate. It's about the fact that you're helping someone. And I think as I progressed through my legal career, it was the fact that the law for me was a vehicle by which I could help. I can remember one particular experience that really took a toll of me at the time. I was a fairly new judge. There was a royal commission on foot, and I was the duty judge. Late on a Friday afternoon, a message came through. The parties involved in the Royal Commission wanted to make an application to the court for an injunction in relation to the disclosure of information before the Royal Commission. It so happened that the next morning there was, or next day, a state election. The parties came to appear before me and I had to make a decision, and it was submitted to me in the course of argument that the outcome of my decision could in fact have an impact on the outcome of the state election the next day. I do remember vividly sitting on that case in the dark with the lights on in the old Supreme Court on a Friday night and having to make that case, and the pressure that was brought to bear by a courtroom filled with barristers and lawyers urging me in different directions. And I had to adjourn, go outside the courtroom and make my decision very, very quickly, which I did. But the pressure was a dark pressure and experience that I would not want to relive. However, again, it was part of the learning experience, and it made me a stronger, better, tougher judge as a result. And as a judge, you have to lift yourself above that and maintain a position that is dignified and impartial. The case must be decided in accordance with the judicial oath, and you do your job. But that is not to say that it doesn't take its toll. Other times that I would prefer, in some senses, not to have had to deal with some horrendous criminal cases where the violence that has been perpetrated by one human being on another, it takes a toll of you as an individual, particularly the cases involving children. But again, you learn how to deal with it.